All right. Hello. This is Rob Ratliff in the Immigration Podcast. And also here is
Susan Hiller with Hiller Legal.
excellent. And so at the end, you'll have our contact information. If you have any questions or anything, as always, feel free to email us or call us anytime and see if we can help you. So, Susan, what's going on in the world of immigration? I haven't seen any real good news lately.
No, it's pretty bad news. I think one of the worst things that has happened has been the Supreme Court's decision to basically allow racial profiling, which is really scary to me as an American. One of the things that I taught at the Federal Law Enforcement Training Center was that racial profiling is prohibited by the Department of Homeland Security as
Yeah.
well as the Department of Justice. And now the way the Supreme Court has ruled basically makes racial profiling, basically, if you're just suspicious alone, it's okay to stop that person and detain them. And what is the suspicion? Apparently, it can be based now on just one fact, which means race alone or the color of your skin.
Yeah.
What are your thoughts on that?
Well, I've always I've always been a little bit more open to race, along with any characteristic, as part of a totality of the circumstances kind of package. Like if the description is whatever the description is. If you're a suspect in a bank robbery, whatever, the description is the description, and some of that is going to be height, weight, gray hair, white skin, black skin, whatever it is. So I've always understood that, especially in the criminal court context, that has a role and a place. But what I found that was interesting about this case was Justice Kavanaugh talked about that totality of the circumstances and race or anything being part of that totality of the circumstances, but then the totality of the circumstances he described were all racial characteristics. It wasn't like he said race plus this plus that. It was all race based targeting. So go to a place where you know that there's going to be people of this group, and then you can target all the people of that group. And I find that troubling that his idea of totality of the circumstances was all the same thing, just in different ways. And I thought it was very interesting, and I didn't see a lot of people connect the two things. But the Korean arrests, the South Korean arrests at the plant in Georgia. Now it turns out not only were these people here on B2 visas or B1 visas, which is completely acceptable to come and work for your company in South Korea in the U.S. on the B1, but then they scooped up other people and everyone that was there. And some of these people had legitimate visas, some didn't, but everything I've seen so far is most of them have legitimate visas. So the totality of the circumstances here was just purely ethnicity and employment, and that was it.
Mhm.
There was nothing.
Weren't they working on, wasn't that actually a unit where they were working on batteries too?
Yeah,
Electric batteries?
I think it was something of some technology oriented entity, and but all the people were B1s, and that's they were
You
setting up
mean,
a company.
when you say B1s, did you mean H1Bs
No,
or
no, B1s. The just
visitor for business?
visitor for business. Yeah, because they were all here to set up and train, and they're being paid in their
Or
home.
that's right, they're just training and they're getting
Yeah,
paid from their home office. So they're
yeah,
just here for me.
yeah. So and that's always been fine. So I mean, it was that was a perfect example, and they came about at the same time. Perfect example of where that race based targeting that the Supreme Court says is okay, there was nothing more than that. If they just simply just check the IDs, and those people end up detained for a week or weekend at least.
And
So,
I think a lot of them said that they're not coming. They will never come back to the United States either,
no?
which is unfortunate. Going back to that, when you were talking about the Kavanaugh's totality of the circumstances,
Yeah.
when he talked about basically he lumped together the ethnicity and the race basically together, it sounds to me like you see a Mexican eating in, or someone you think is Mexican eating in a Mexican restaurant
And speaking Spanish.
and speaking Spanish, yeah,
Yeah.
and that alone is enough.
Yeah.
That would be akin to an Italian person eating at an Italian restaurant and speaking Italian.
100%.
I can do all of those things, by the way, and does not make me.
Carry your papers wherever you go.
Well, I thought as an American citizen, I don't have to.
Yeah. Well, and that's.
And then if I'm deprived of my, what if they, okay, for example, you and I,
Mhm.
what if they presume, I don't know what your background is, but let's, Irish, English,
Yeah.
European of some sort,
Oh yeah.
they decide, they overhear you putting on an accent from one of these countries, that, and you're eating food from that country, and they just detain you, and then you're trying to tell them, no, I'm American, I'm a U.S. citizen. You've already been detained, you've already lost that day, maybe you lose a whole week because now you need someone to go get your documents and they don't believe you.
Right. Yeah, and that's especially risky. And we just did a blog post about it. I guess last week or so, about 10 days ago, maybe, um, about having that emergency plan now. If you or anyone in your family is, you know, some sort of questionable status or of any ethnicity or anything, you better be ready. You better have something set up, emergency contacts, know who's going to be able to come and get you or apply for that bond or whatever it is. Um, Copies of your documents, copies of your paperwork. It's better have
But
it.
it's unfortunate because that our children's generation is the most ethnically diverse generation in the entire history of the United States. So, and they're U.S. citizens.
Yeah,
I'm talking about ones that are, of course, either naturalized or naturally born here. They shouldn't have to worry about that. And now with the Supreme Court's decision, I mean, if you have a child in like you said, a certain neighborhood, and then they have some type of maybe skin color to them that they decide to just lump them in. Uh, I think those two things alone is what the Supreme Court is saying. Of course, if you're speaking another language, that definitely. But my understanding is suspicion alone is what they're allowing the detention on, and to me, that's it's no longer the way that we've taught a Terry stop and
yeah,
detention.
yeah. And I think even one of the things that Justice Kavanaugh said in response to one of the dissents was that, well, if you are a citizen or a permanent resident, the fact that you may undergo a brief detention, well, it'll be brief and it'll be okay, and you won't have to worry about it. Well, I shouldn't have to be detained for anything ever unless there is a reasonable articulable suspicion that I've done something. And you know and my
Right.
my complexion and my language skills, I don't know, that just seems to me that they took that totality. They're doing two things. I mean, they're saying totality of the circumstances, which I think many people would say okay as part of a total package, maybe, but but they've made the entire total package just 4 or 5 different ways of looking at the same thing. And
Right. And when we taught at the academy, again, we taught it cannot be just based on race alone, which means, for example, and I actually would use the example, a Mexican looking person eating Mexican food in a Mexican restaurant speaking Spanish, not enough. That all goes to race. That all goes to ethnicity. It's the same thing.
yeah,
You need more than that. You need something to tie to the illegal activity or the violation of administrative law. And that alone, there are plenty of American citizens and legal immigrants that do that. So you cannot use that alone to say that's enough for the detention, because you have nothing on
yeah,
the articulable fact that they're unlawfully here.
yeah, yeah. There's nothing. It is all to physical characteristics or time and place characteristics, and nothing articulable about an underlying crime. And
Right.
that's very, very different than anything we've dealt with before. But in the criminal context or anything, there's always some suspicion of a crime. Has always been part of that articulable suspicion. And just some people at a work site speaking another language and looks like you're not from around here, kind of thing, is just that's much, much broader than anything I've seen. So it'd be very interesting
And
to see what the court does on remand with it, though, because
oh yeah,
it's just a remand. So I don't know. I mean, that's going to be really interesting. But
I have a question for you on that.
yeah,
So you said that the court said that, well, if you're an American citizen, it's just a brief detention. It shouldn't really cause any damages. But let's say that you were on the way to the hospital to say goodbye to your mother
hmm
or your father who's dying in the hospital, and this is your last moment. Um, that brief detention that should have never happened is keeping you away from that moment or the birth of your child
yeah,
in the hospital.
yeah. It's that butterfly effect. I mean, who knows what comes from that, and who you get scooped up at 6 o'clock on a Friday on Memorial Day weekend, Tuesday, maybe
Mhm.
before you see a judge, if you get to see a judge, which is another issue that we should talk about as well, and that's the you don't even get to see a judge now, depending on what category you fall into. So and the other one of the things that I think is important about that Supreme Court decision, that in the fact that it's getting remanded. And I think this is part of a greater pattern we're seeing with all the DHS actions and things now too. I don't know if you've seen the Fourth Circuit decision recently on the material support bar. That
I saw it, but I haven't had a chance to read it. So I'd love to hear
well,
your thoughts on
one of the things that was very good about the decision was, well, two things really. One is it really went at some of the Chevron deference that DHS and they've taken advantage of in the immigration context. So it set aside some of that, and then it really just said, material support means something. In that particular case, the guy took a job as a cook. He's there for a couple of weeks. Thinks, this is maybe not what I thought it was. Tries to leave. They don't let him. And the court said, that's not material support. And that's very different than what the BIA standard is right now with the woman that was held captive and forced to cook and clean. But that notwithstanding, the issue that I thought was really important, and I think it's important in the context of the Supreme Court decision, was the case had went to trial, the guy lost. The case had went to BIA, and the guy lost on the material support issue. It goes to the circuit court for review finally. And this is several years later, right? By the time the circuit court makes a decision, a published decision even, in the Fourth Circuit. You know how long that takes. Um, the court said, yeah, this is wrong. This isn't material support. I'm remanding everything back. I'm vacating the removal order. And oh, by the way, since the guy's already been deported, um, you know, have a nice day. So so the guy's already gone, and
Yeah.
he was here seeking asylum, and clearly he had run afoul of actual terrorists in his country because DHS was saying you cook for these people, so you're part of this terrorist group. So clearly he ran afoul of terrorists in his country. They're clearly trying to kill him because he fled, and he's already deported before he finally gets a decision on his case. And you
What
got
country was that from?
Nigeria.
Okay.
Yeah.
When I was DHS counsel, I had a Cook case where the person was Guatemala,
Mm, yeah. Yeah. And
and who they cooked for now is considered a terrorist organization because they're drug traffickers. Um, but that one I don't believe was up. I think it was granted by the judge and not appealed
yeah.
by DHS.
Yeah. Those material support cases. I mean, it was the BIA standard was so low. I'd see several come across. When I was on the bench, I'd seen several come across, but the standard was just so low. There was nothing you could do in many of those
Mm,
cases. I mean, it was clear, and but this changes things dramatically with respect to what DHS is, the deference that DHS is entitled to in some of those situations. But again, it goes back to what my fear is on the tying into back into that racial profiling decision. Now you're detained. Now DHS is going to argue material support based on you paid extortion money to whatever Clan de Golfo or whichever group it is down there, and now they get mandatory detention on you because they throw in this material support bar in.
mm,
Now you're out of you may win your case 2-3 years down the road, but you're already deported back and dead maybe. And
mhm.
so what good does it do at that point? And that's the same thing we've seen. And I don't, I'm a little bit older, but uh, with the St. Cyr decision, all those people that got deported between
Yep.
April of '97 and I think it was like May or June of 2001 when St. Cyr came out. All those
And
people
just so
got
you know, I'm probably as old as I'm with you on the age thing actually,
yeah,
because on St. Cyr I was practicing in Boston with INS, Immigration and Naturalization Service,
yeah,
Office of the District Council. So I actually saw St. Cyr cases.
yeah. I had one of
Yeah.
the first post St. Cyr decisions out of the Second Circuit at the time, and the only reason we won was because the client had already been deported, and uh, just shortly after St. Cyr, or actually before St. Cyr came out, and we were in the process, he had attempted to re-enter and got stopped at the border, and they charged him with illegal reentry. And had they not done that, he'd have never been able to take advantage of it. But because they nabbed him for the illegal reentry, we were able to, eventually you got the illegal reentry dismissed in federal court, and then got him back into immigration court and went through the whole process. But I mean, his plea agreement was specifically designed to be able to take advantage of 212C relief, which was
Right.
relief for aggravated felonies that existed back then. But by the time the sentence was over, the laws had changed, and so it's the same thing now though with these things. They're gonna. I think the whole plan is we deport as many people as we can, and if the law changes, as the court says that was improper, well, too bad, you're already gone.
Oh yeah.
And what's your remedy at
Or
that point?
they'll reopen cases and retroactively apply a new version of the law where we're now using Chevron deference, which actually the Republicans who are in power now actually fought to overturn Chevron deference, but they're actually actively using Chevron deference to try to articulate that you need to do whatever DHS says because we know best what Congress intended when they wrote the regulations,
Yeah,
and we know best what material support means, which cooking for a group you might not even know is a terrorist group or wasn't on the terrorist list at the time, and you're fleeing for your life because you really did work with this really dangerous group
yeah,
who you know too much about, is now material support when it wasn't back then.
yeah.
I feel like they just want to deport as many people as possible, even those who are legally here, were legally granted previously. And um, well, on that note, I also want to introduce the topic of USCIS are now special agents with guns.
Yeah, yeah. So you can go for your asylum interview and leave arrested.
Yeah.
And I assume that they just didn't hand out a bunch of guns to USCIS. I assume they're going to make them take some sort of training, or I hope.
They claim that they're going through the same training that the special agents go through, but there's no way. I taught again at the academy. It's the new special agents. They never said new special agents, so that's really
Yeah.
important to note. And they're using the media and DHS are purposely, DHS is purposely doing this, not the media. The
Hmm.
media is just mistaken. They're purposely using the word agent and officer interchangeably. You don't even hear the word officer anymore.
Correct.
They're calling deportation officers special agents. They're just saying agent,
Yeah.
the agent, the agent. Um, so we teach, when I say we, that's the old me,
Yeah.
new me. ICE teaches advanced courses at the federal law enforcement training centers for deportation officers. They have to go back and do additional trainings. Um, I would assume that's what they're putting them through because they already know immigration law. But then again, they have to teach them firearms. Um, they need to teach them, what do you call it? Defensive tactics.
Hmm.
They also are supposed to actually be able to pass a physical fitness test. Um,
Yeah.
but they're probably waiving so many things for them, although they claim they're going through the same training. I don't believe it because they're rushing this all out. And if they've already become, President Trump has been in office since January 18th, was it 18th, 19th, 20th,
25th or whatever. Yeah.
25th. All right. So it takes time for those executive orders or policies to go down, and they got to go through. I don't know if I've explained this before, but I did a detail to ICE OPLA's headquarters at the Executive Communication Unit.
Hmm.
It's quite impressive because I did like seeing that this is the way things did work. That when the policies come out from ICE headquarters, they have to go to almost every unit that is impacted by it. So it would go to enforcement removal operations if it impacted them, as well as OPLA, the Office of Principal Legal Advisor. And each subdivision component will comment, and all those comments get put together by the executive communication unit and sent to ICE headquarters. And they take into consideration all those comments. Like, so if the Office of Principal Legal Advisor during Trump 1.0 said portions of the policy they wanted to pass were not constitutional and needed to be revised, they are supposed to take that into consideration, revise the policy, and send it back down. Each section comments on each other's, and it's sent to each division head and each part of the component that has an interest in it. So if there's a national security subcomponent of the Office of Principal Legal Advisor, which there is. You send it to that division within OPLA, and they comment on it. So the same thing happens with the other components like HSI and ERO, Homeland Security Investigations, and enforcement removal operations. And it can go out to other components too within ICE. Trying to think of some of the other components, but right now, in any event, then also there's also the people who deal with labor and management. So those components are within OPLA, and so they get to comment as well to make sure that they're not violating statutes with regard to labor matters. So you have all these different components. So I guess my point is with the special agent thing with
Yeah.
USCIS is that how do you get that memo that's still at the very beginning of Trump 2.0, has to go through the right channels because you haven't fired everybody yet to make them not follow the proper procedure.
Yeah.
And even if right now there's a lot of yes men, they're still going through that procedure. It still takes time. So let's say, I don't know, that got implemented in May. We're at that's just the
Yeah.
best case scenario. June, July, August, 3 months. The academy is like at least 4 months.
Yeah. Yeah. It's 12 weeks, right? Or 16.
And they would have had to have
16.
not only gotten those people to actually want to do this, they'd have to get them to the academy, which takes time because they got to schedule the classes. They have to make sure the instructors are available. I worked at the academy too, so I know the difficulty in implementing that. They've got to make all the travel arrangements for all the people. They have to have the money has to be there for the budget, so they have to go through all this budgetary process as well.
Yeah.
So, long story short, I don't see that they would have gone through the same training,
Well,
and that really scares me with weapons
oh yeah,
and
yeah.
them being out in the streets.
Well, in the streets, and then just the chaos of an asylum office. You know,
Mm-hmm.
you've been to some of the big asylum offices. Atlanta, New York. I mean, there's 1,000 people in there,
Mm-hmm.
families and babies and interpreters from all over the world, and I mean, it is chaotic, and I don't know that I want a whole bunch of people running around with guns. Um, and even with you know I would assume that it's a different, and again assume, but I would assume it's a different level of security check. I mean, are all these people doing the FBI check? I mean, I know when it took like 6 months for that FBI check to clear, to go
Yeah,
to
it's
DOJ.
it's at least a secret. They might already have a secret clearance. I mean, to get to be a supervisor, then you're going through a top secret clearance, which is
Yeah,
longer. Um, but I can see them. I can see when they're trying to do this emergency, such an emergency. I mean, yes, there was stuff at the border. We all know that.
yeah,
But interiorly, right now, um, if he screamed emergency, and then they probably basically just used their prior clearance and said, well, we'll just wait for the next 5-year clearance to re-clear them. But I mean, the problem I have with it is benefits. One of the things that we modeled that off of when we became Department of Homeland Security, again, that's the old me,
yeah,
the old me. So I say we, but we as a country had a Department of Homeland Security, was to separate the benefits section from the enforcement section
exactly.
because we were all one before. And Immigration and Naturalization Service had an examinations unit, and they had a deportation unit, an investigations unit, and the trial attorney unit, and they all worked for the same district director. And it's an easy phone call to have someone picked up. Um, Now they've separated them so that they have separate missions statements.
Hmm.
They did, and separate, separate agency heads. They were separate agencies. We became sister agencies, the enforcement agency, but we weren't the same.
Right.
And over time, it took a while, but over time, it was very distinct that USCIS Their mission was benefits. If you could send something to them from ICE to alert them of something, if you saw something in court as a assistant chief counsel,
Mm-hmm.
but they stayed in their arena,
Yeah.
which was benefits, and they did not they didn't say, oh, we're going to do what you say. They may look at it, but they made sure to keep their independence, which I really do respect. And now it's looks like it's gone.
Well,
It's really gone.
yeah, and I think that's what we're seeing is we're seeing this uh, moving everything into this one silo where it's DHS from it's ICE ERO from beginning to end. They're deciding what the charges are. They're deciding whether or not they've met the standard of proof for the charges. They're deciding whether or not you're subject to mandatory detention and the judges can't review it. They're deciding whether or not you get deported, and it's all in one agency. And I think that's why we've seen 100 judges get fired in just this year because they don't want them. They don't want judges. Bringing in
They don't want judges.
right. They're bringing in military officers, which I
They're yes men.
I think they may be a little bit surprised in the independence of military officers from time to time, but military officers are also very good at taking orders. So, if the order is deport that person, they're going to do it. So I don't know. I think I just think I see it more and more of it's just this one stop shopping from we're going to pick you up, we're going to detain you, we're going to determine that you're not allowed to be here, and we're going to throw you out. And there's no ways around that, and nobody to. More importantly, there's nobody to review it because the federal courts um, are haven't caught up to, again, going back to the Chevron deference, the federal courts haven't caught up to, hey, the policies and the regulations that DHS is doing all this under aren't entitled to the same deference anymore. In
No, in
Europe,
fact, literally, I wouldn't even be looking at the regulations the same way after Chevron. Like, how can you? They said that the agency is not entitled to deference for the regulations. The regulations were written completely by the agency.
yeah,
And now you get to look at the law and find out what Congress actually really intended. So
yeah,
you almost need to push the regulations aside because if you look at for example, the T visa regulations, they're monstrous.
mm-hmm.
I don't know if they're 100 pages, but it's this thick. Okay, the regulations when I printed it. Congress made a visa for people who are victims of trafficking, of the severe form of trafficking. It could be sex trafficking, human trafficking, labor trafficking. And now the USCIS has decided, well, we're going to make it so difficult, so cumbersome. We're going to add in things that are not in the Immigration and Nationality Act
yeah,
about, if you go back to your country, or how do they feel about these types of trafficking? All these different questions that have to be answered by, obviously, you got to have an attorney because that type of stuff, you need country conditions and all kinds of, there's things that actually a layperson may not be able to explain or articulate.
yeah,
And my point on that is the law does not say that. The law written by Congress was for these victims. It was not for USCIS to make it almost to just make it so burdensome, because Project 2025 says that they want to eliminate the U and T visas from the Heritage Foundation. That Heritage Foundation is not Congress. They didn't pass the law. And USCIS is not the Heritage Foundation. And they shouldn't have been
yeah,
implementing regulations, again, that shouldn't have deference.
yeah,
Shouldn't have deference.
yeah. And I was never a big fan of the Chevron decision, anyways, because I felt like many things, Congress has failed to act and and continues to fail to act by allowing agencies to do things that they should be doing. But the interesting thing right now is and not everybody understands, but the courts are under the Department of Justice, and immigration enforcement and the OPLA attorneys and are under DHS. So technically two different cabinet positions. But we're in a situation where DHS is determining, much like the Solomon case that's in the news all the time that we're doing or in the most recent decisions on the iwi cases, mandatory detention for anybody that entered without inspection. DHS is making those.
Stop there for 1 second, Rob.
Yeah,
Explain that to people.
yeah.
Anyone who entered the country without inspection
Yeah.
is in mandatory detention?
So in a complete policy change, the Board of Immigration Appeals has acknowledged and accepted that DHS's new policy of they've redetermined the mandatory detention policies, and DHS has said that no, the policies as written really say, after 25 years, they really say that no, if you entered without inspection, you're not entitled to bond, you're subject to mandatory detention. And the Board of Immigration Appeals has just recently upheld that. So as it ties into which basically means about 90% of the people that have come, came without inspection. But as it ties into the Chevron deferences, now we have the Department of Justice, one agency, one cabinet agency, saying to another cabinet agency, Department of Homeland Security, that yeah, you still get deference. We're not going to stand in the way of you determining what your own regulations say. So I mean, again, it's DHS saying we think the regulation says this, and we're going to implement it that way, and nobody can review it. So now immigration judges have no opportunity.
DHS is telling Department of Justice what to do, and Department of Justice is saying,
Yeah,
"Oh, definitely."
Chevron, or they're not saying Chevron, but they're saying your regulation, you get the authority to do it. So it's
So where's the judicial independence on like Cersei Owens tries to claim?
yeah,
Where's
exactly,
their
because we're
judicial
just
independence? I'm just wondering.
and the federal courts have got to step in at some point and say no. DOJ has a separate and distinct role in the immigration process, and they can't just abdicate that to DHS. Now, if and I think more importantly, the actual statutes are what give DOJ that role,
Right.
and so DOJ, in my opinion, doesn't have the authority to abdicate that
Well,
role.
I feel like when I'm listening to this and you saying it, it makes it quite clear that what they're trying to do is eliminate the need for judges because, and I don't know if the judges realize as a collective whole that the more that they allow the Department of Homeland Security to do whatever they want, which is again, they're agreeing to everything DHS says
Yeah,
because that's what they're told to do by their bosses in order to keep their jobs, which is again, I think if I haven't said this before, I think some of these are illegal orders because they're having them act contrary to the law. Um, they're basically eliminating the need for their position. Why need them if you're just going to do whatever DHS says? So you eliminate them. Eventually, then you might even eliminate the attorneys, the assistant chief counsels. Because if the assistant chief counsels are just doing what ERO says, you get down to the officers deciding everything, which is what under Trump 1.0, a deportation officer, a supervisory deportation officer told me that's what the Trump administration said they wanted to do. And this person was in close contact with the people on Trump's team. So the goal was to actually have the deportation officers doing everything.
yeah, and there was a lot of policies back then that were steering things that way, steering things to asylum officers first, and I think we're continuing to see that now with the interior using on the interior enforcement, the expedited removals and things like that. So it's a tricky time, but I think you've got to be prepared to litigate. And I don't think you're going to get an immigration judge to do it right now, but I think you got to be prepared to litigate in front of that immigration judge that judge this regulation that DHS is saying that they're not entitled to any deference on that. They're just not. It
Right. I think everyone needs to be saying that.
yeah
Like every immigration attorney needs to keep articulating that Chevron in deference no longer exists, and we need to look at this congressional act in accordance with what Congress intended.
Yeah. Yeah.
And Congress did not intend at that time. I mean, I'm sure we can go through the actual legislative history, but the fact that Congress only allowed and funded for, I don't know if it was 40,000 beds, but they had a limited bed capacity
Yeah.
at the time. And even before that, it was even lower when they created these laws. So that tells you with their legislative intent, they didn't intend for every migrant or non-citizen to be detained in mandatory detention. They meant for the worst of the worst, and those who, you know, they could at their discretion, those that came in at the airport, port of entry, or at the border because they didn't know who they were.
Yeah.
But they had a right to a bond hearing.
Yeah.
Even those people, until expedited removal, I mean, there was some changes with regard to the law,
Yeah.
but it was meant for the border and to protect the United States from who's coming in, who's applying to come into the United States. Do we know who they are and what their true purpose
Yeah.
is?
And I think one of the things, because of that lack of bed space, now we're seeing all these contracts with county jails, and the county jails that are participating in those 287G programs, they love it. I mean, I've been a city administrator. I get it. They were getting 3 times the going rate for their jail bed. But yeah, but what local people in their county need to understand is that for every guy that just entered illegally 10 years ago and he's been working somewhere and now he's detained, he's taking up a bed. So the guy that's robbing the bank or beating his wife or selling meth, there's no bed for him, so he's out on bond. And the mandatory detained guy is the guy that was just here and working at the construction site and got scooped up because he spoke Spanish and worked at a construction site. And now he's
Yeah,
mandatory
and
detained.
maybe they would also they could consider the fact that their Medicaid for their disabled child or for
Yeah.
somebody in their household or for their grandmother who's at a nursing home, because Medicaid actually pays for a good portion of nursing home fees for the elderly. When that comes to fruition in 2026, yeah, your money, instead of going to you as an American citizen, went to deal with, like you said, Joe, non-citizen, who was just working,
Yeah.
mowing grass, landscaping,
Whatever.
and
Just mandatory detained
never
now.
committed a crime except maybe driving without a license. But other than that, and they'd like to tie in entering illegally as a crime, but it's you know it, it doesn't.
Yeah.
It's an administrative violation. There is a crime for it, but it's a federal misdemeanor. And in any event,
But he's taking,
besides those
yeah.
things,
But
he probably goes the speed limit, unlike
yeah.
the rest of us. And yeah,
And taking up bed space for, your local drunk driver, meth addict, whatever. So,
well, and our taxpayer dollars
mhm.
are not being used wisely.
Right.
It's not being used on Americans
You're
first.
right. Well, Susan, good to see you again.
Good to see you again too,
Yeah.
Rob.
And remember, there's things at the end for all of our contact information. You have any questions, give us a call and shoot us an email. And
Yeah, and it's really important to have an attorney right now. So
uh,
if you don't, make sure you get an attorney, because to navigate through all this, you need an experienced attorney to help you.
well, and it changes every day. Changes every day, more than I've ever seen in almost 30 years now. So,
Yep, me too.
yeah. All right. Good to see you.
Good to see you.
All right.
Bye.
Bye.